Think you can't get a green card because you overstayed your visa or entered without inspection or worked without permission? Well, VAWA changes some of those rules. If you're a self-petitioner, those past roadblocks may not apply to you. Let's talk about how. I'm U.S. immigration attorney Lillian Chukwurah, and I help my clients get green cards and citizenships for themselves and their families using the U.S. immigration law system. If you have experienced abuse in your relationship with a U.S. citizen or a lawful permanent resident, you may qualify to get a green card on your own without needing their help or consent. Today, I want to talk you through how adjustment of status under VAWA works and why some of the common reasons people get denied don't apply to VAWA. Normally, when people try to adjust their status in the U.S., they run into bars, reasons USCIS can deny their application. But under VAWA, two major bars do not apply to self-petitioners. The first one is working without authorization. You worked in the U.S. without getting a work permit first. Under VAWA, that is not going to block you from getting your green card. It is treated similar to immediate relatives of U.S. citizens because immediate relatives of U.S. citizens do not have to worry about working without authorization, just like VAWA self-petitioners do not have to worry about working without authorization. Secondly, overstaying your visa. If you came into the U.S. with a visa, but you stayed past the time you were authorized to stay, even if you overstayed for a few months or even years, VAWA still allows you to adjust your status. This isn't just a USCIS policy thing, this is actual law. The Violence Against Women Act actually has this in it. It gives these exceptions. So it's not just USCIS policy that allows for this to happen. So the presidency can't change that without changing the law. The way to look at this, if you're thinking, oh, well, why do they get special treatment? You have to remember, VAWA is specifically for victims of abuse. And this is a way for a victim of abuse to not only get free of their abuser, but to be able to rebuild their life. And if they have these bars preventing them to get a green card, it is going to be very hard for them to rebuild their life. So that's why it's built into the law. Now let's talk about the next huge roadblock for many people. So U.S. immigration law says you usually can't apply for adjustment of status unless you were inspected and admitted or you entered with parole into the country. That means coming through an airport or being formally allowed to enter the U.S. So that's admission or parole. You need to have one of those to apply for adjustment of status. But VAWA has an exception to that. The law says that someone who has an approved VAWA self-petition can still adjust their status even if they were not formally admitted or paroled into the U.S. So if you entered without inspection, but your VAWA application, your I-360 application was approved, then your adjustment of status application can be approved even though you entered without inspection. Now, we still have to screen for other things like prior deportations or criminal records, but entry without inspection by itself is not an automatic denial for a VAWA applicant. Like I said before, that is a protection Congress created specifically for survivors of abuse. If you are getting value out of this video so far, please don't forget to hit that like button and then tell me in the comments what is one question about VAWA adjustment of status that you haven't gotten the answer to yet, so that I can make sure to answer it in a future video. Now let's be honest, VAWA removes a lot of barriers to getting a green card, but it does not erase everything. you still have to be admissible. That means USCIS still has to check for things like certain criminal records, immigration fraud, health grounds, past deportations. But here's the important part. VAWA gives you special access to waivers, which is like a legal forgiveness that is not available to anyone else. So for example, if let's say you had immigration fraud or you had certain criminal records that can be waived, but typically in order to apply for a waiver, you would need a qualifying relative, meaning you need either a US citizen or permanent resident spouse or parent that would be the qualifying relative for the waiver. But in a VAWA situation, if your qualifying relative is your abusive spouse, then they are not a qualifying relative. What do? A VAWA applicant can be their own qualifying relative. So when it comes to extreme hardship waivers, a 601 waiver, you do not need a qualifying relative. You, the VAWA self-petitioner, can be your own qualifying relative. Another type of waiver that is specific for VAWA self-petitioners is if you have a permanent bar, which is where you entered the US, either you stayed unlawfully in the US for about a year and then you left the US and then entered the US again without inspection, or you were deported from the US and then you entered the US without inspection. In those situations, you will have something called a permanent bar, which means you will not be able to get a green card in the US. You will be able to leave the US for 10 years and then be able to apply for a visa back to the US. Now, if you are a VAWA self-petitioner and the reason you return to the US the second time without inspection is because your abuser made you come back, if you can tie that return to the US to the abuse you have suffered, you can get that waived. So that is one of the few ways that a permanent bar can actually be overcome. So this is, again, a special thing for victims of abuse. And this is where strategy matters. Your case needs to be built carefully to show how the abuse connects to the immigration issue so that you can still be able to get your permanent residency. I personally work with my VAWA clients to make sure that they know their rights, they know what they qualify for, and we are exploring all options to make sure that not only do they get the VAWA I-360 approved, but that we can also get the I-485 approved. In some situations, you may not be able to get permanent residency. However, your VAWA approval gives you deferred action and you will be able to renew your work permit and live in the US with that VAWA petition being approved. However, most people want to get their permanent residency, and that's what this video is about, is to give you options, because you may be sitting there thinking, oh, I entered without inspection, or I worked without authorization, or I overstayed my visa, I do not qualify, right? Or I need a waiver, but I don't have a qualifying relative, oh, I can't apply for VAWA. No. Those things only applies to the adjustment of status. You can still get VAWA with a permanent bar, right? You just can't adjust your status. So it's really important that the strategy matches your own story, right? Matches your real life experience. And what I have found in my 10 years of doing this is that no two stories are exactly the same. And what matters in this whole process is that we listen to you, we plan, and we protect you throughout the process. Because the whole point of the VAWA existing in the immigration world is to make sure that victims of abuse are able to gain a lawful permanent residency without having to rely on their abuser, which would then, in most cases, result in more abuse. If you are ready to figure out what you qualify for, if VAWA is a real option for you, go ahead and schedule a free strategy session with me. I offer a free 15-minute session where we talk and figure out what you qualify for and how you can make your goals a reality. You can schedule that by going to my website, lilylegal.com, and clicking on Contact Us, where you can pick a date and time that works best for you for us to chat about your situation. And remember, you don't have to figure this out alone, and you don't have to stay in limbo. You can get answers and figure out what your next realistic steps are.